Welcome to the Retzel Health Law Hotspot. Health Law Hotspot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. Welcome to the Health Law Hotspot. I'm Arca Adler, shareholder and head of the Health Law Practice Group at Retzel and Andrus. And today I am joined by my colleague, Lesley Arca, who's also part of our Health Law group, and a very special guest today, Anna Krolikoska, who's an attorney at the law firm of Anna P. Krolikoska, and who focuses her practice in the area of family law. Specifically, she's going to talk to us today about some of the marriage and divorce issues and considerations that physicians and other healthcare providers need to make. Now, marriage, divorce, why is that different if you're a healthcare provider versus if you're not? Well, actually, it makes a very big difference. And there's a couple of different reasons, and we're going to discuss that today. First of all, if you're located in a state like Illinois that has corporate practice of medicine, as a licensed person, you can own an interest in a medical practice, dental practice, veterinary practice, etc., because you have that license. And in some states, it doesn't matter that you have a license, but in many states it does, which means that if you get divorced or something happens to you, that cannot automatically pass to your spouse or your family. So those are some special considerations. The other thing to think about is that a lot of physicians and other healthcare providers have an ownership interest in, let's say, a surgery center, where they're allowed to own that interest and participate as a result of their licensure. So you can see that there's a couple of interesting issues that arise because healthcare providers are licensed. And that does have a direct impact on family planning in terms of maybe your estate documents, in terms of a prenuptial document, etc. So we're going to talk about some of these issues that are really specific to our licensed professionals that are listening. And so I want to go ahead and welcome Anna. Thank you for joining us today, and we really look forward to your thoughts on these topics.
My pleasure, and thank you for inviting me.
So why don't we start off by you just telling us a little bit about some of the types of situations that you handle with your clients. So we have a little bit of an idea of your expertise and the kind of services that you offer to your clients, and then we can kind of apply it to the licensed professionals.
Sure. So I help clients who are in need of prenuptial agreements or postnuptial agreements, and those are methods of trying to address property concerns either before the marriage takes place or after the marriage has taken place. And they're slightly different, and we can talk about that a little bit later. The other big component of my practice is helping divorcing clients and divorcing couples. And for that, I offer collaborative process divorce mediation or litigation services. And I think, and I think it's incredibly useful to talk to someone who's familiar and practices in the three modalities so that they can give you perspective in terms of how would a different process play out under your specific circumstances.
Okay, so when somebody comes into you to see you and they're a licensed physician, dentist, or other provider, and they say to you, look, I want to make sure that I am protecting the money that I make in my practice. Is that really any different than anybody else with any other kind of profession? I mean, I don't think they can do anything particularly different. And here I'm not talking about like state laws, but what are some of the things that people should be thinking about if they are concerned about protecting their assets in that way?
So if they're not married, if they're contemplating getting married or they're engaged, a prenuptial agreement might be in order because it allows them to talk about accumulation of assets, both premarital as well as during the marriage, and it can help them also talk about income. Because generally, once you're married, whatever you earn through your efforts is marital property. So there might be a distinction between the efforts of an individual versus income that is received through a business entity. So that might be something to consider. If we're talking about a divorce situation, then we would look to how was the practice structured what was their employment, meaning were they an employee of a hospital, for example, or did they own a practice? And also look at what approach might be best for a divorce in their circumstances. So whether that's collaborative or mediation, or unfortunately, sometimes litigated approach. And also, how would a court view the assets that were accumulated? What is the situation in terms of any spousal support? What is the situation in terms of any child support? And so it's a longer conversation.
Okay, so if you are just, let's say, finishing your training and you haven't really started practicing yet, versus you're getting married and you're already a very successful healthcare provider, is there a different approach that you would take, or is it always going to be, whatever you had before you got married versus what you had after you got married? Is that always the cutoff?
No, it depends what you do with it. So that's why a prenup might be an appealing outcome or solution for you. Let's say you are a part of a practice, you've bought into the practice, and there's some value accumulated there. In a prenup, you could say, this value remains mine. Whatever grows out of it in the future remains mine. And then address the question of income. Because if you create a prenuptial agreement where you just say, all the income that ever comes from this practice is mine, you're going to have a hard time having a judge uphold that prenuptial agreement in the future. And that's what you want. When you're creating a prenup, you want to make sure that there's plenty of time for consideration of that prenup for both sides. You want to make sure that each side is represented by an independent attorney. And you want to make sure that there's a full financial disclosure, and that the prenup is not so one-sided that a judge looking at it in the future would say, absolutely not, I cannot uphold this agreement. It's unconscionable. So it's a very delicate balance that you have to maintain.
So Anna, what about the situations where there are more young physicians who are entering into long-term relationships but aren't necessarily thinking about marriage?
So are you talking about a cohabitation agreement, for example?
Yes, that's one of the avenues that I've heard of, and that's new terminology that's come up.
Okay, so under Illinois law, if you buy real estate and you're not married, you would have to or want to figure out how would any property rights accumulate in that property, especially if maybe the two people buying the property are not contributing the same amounts to it, either for the purchase or for the maintenance and upkeep long term. Also, Illinois is one of those states that does not recognize common law marriage. So there are states where if you live with someone for 7 years and you present yourself to the community as a married couple, common law marriage exists. In Illinois, we specifically do not recognize that. And because of that, in Illinois also, there is no spousal support or palimony or alimony if the couple is not married. So that might be another item to consider in the cohabitation agreement.
Okay, and just to note, people listening to this may not be in Illinois. So really the thing to take away from here is that you have to find out what your own state requires. Now, if you're joining a practice, let's say, and I work with a lot of different practices, a very frustrating issue is when one of the physicians in the practice goes through a divorce and they have a lawyer and maybe rightly so, are seeking a large amount of information, very repeatedly so, about the practice, about what doctors, not just the one getting divorced, doctors in the practice are earning, what the revenue of the practice is, etc., which can be super intrusive. It can be expensive for the practice. What do you suggest if you can kind of wear the hat of the business owner as opposed to, the lawyer for the doctor who's getting divorced or the spouse that's seeking this information? What are some ways that they can kind of nip that in the bud so they can avoid, if possible, having to go through that process to begin with?
That's a great question. So if you are the doctor, come and see me or someone like me. And by that, I mean someone who practices in collaborative process, mediation, and litigation, because you have a decision to make at the beginning. And that decision is, which process will I use? With collaborative process and mediation, you're steering towards alternative dispute resolution, and you're able to create a process where, one, you have greater control of what happens in the process. You can maintain confidentiality. You can create at the outset a situation where it does not have to become a war of the roses. It does not have to be a very intrusive, litigious process that's taxing on you and your colleagues in the practice, co-owners in the practice. So for example, in collaborative process, at the get-go, the couple would agree that they're using this process, and the couple and the professionals would sign a collaborative participation agreement. And it includes in there that you're going to maintain confidentiality, that there will be a status quo maintained without any significant changes unless the couple discusses those changes and agrees. And then there will be free and full disclosure of financials that are necessary for the process, right? So in collaborative process, we don't send subpoenas, we don't send discovery, because we would bring in a financial neutral whose role it is to help this couple, especially in a situation where we have a spouse who maybe is not familiar with the family finances, maybe has been a stay-at-home parent, and is frankly at that point very concerned in terms of financial future and well-being. So that financial neutral can work with that person to help them understand what there is. He or she can review financial documents and also be able to say, yes, we really need to see this, but we don't need to see that other thing that's a big concern to someone, because it doesn't really impact the value of the practice, right? So it's helpful to have that professional who can say, yes, this is important, but handle it in such a way so that it's not disruptive. You don't have that control in a litigated process. In a litigated process, you can anticipate discovery going out. You can anticipate that you will likely have to have some sort of evaluation prepared in terms of what is the value of the interest in the practice. And if you as the physician have your own valuation prepared, it is very likely that your spouse will not just take that valuation at face value, but they will want their own expert to review all the documents and come up with a valuation. And it is very likely, again, in litigation, that those two valuations will be very far apart. So then how do you figure out the value? Do you reach an agreement, or are you then going to trial and a judge makes the decision in terms of what is the value of the practice, which would be step one. Step two would be the non-physician spouse cannot own that interest. So how is any marital share of that interest bought out? Are there marital assets other than the practice that can be used? And can you shift those to the non-physician spouse to offset the value in the practice? For me, in terms of divorce, it's often a puzzle. How do we put this puzzle together so that it makes sense? And I find that those clients who use collaborative process and mediation really are able to craft outcomes that are better suited specifically to their family, rather than the cookie cutter approach that a judge might be forced to offer because that's what the statute restricts or allows him or her to do in a specific situation.
Makes sense. So let's say they didn't have this discussion ahead of time about the process they want to use. Is there something a practice can do in terms of its ownership documents where, a doctor who's going through a divorce can be terminated, for example, or if your ownership in a surgery center, for example, can divorce be used as a grounds for termination? And does that actually then, avoid, let's say they did not choose that collaborative process, does it avoid some of the, the unappealing process from happening? What happens typically if somebody's terminated, there are provisions in the document say, oh, you were terminated, this is the buyout formula, this is what you're getting, and you're done. So there's really nothing to discuss. It's the formula, and usually the corporate entity gets to figure out that price based on how their documents are written. Is that a potential solution if you're on the entity side. And you could encourage people to choose that collaborative process, but certainly can't dictate it amongst your doctor owners.
You absolutely cannot, and you can't even dictate it to your spouse. It's absolutely an opt-in voluntary. Are you choosing collaborative process? Are you choosing mediation? And if you don't, the default is the traditional litigated process. As to what an entity can and cannot do, I think that's more your wheelhouse in terms of advising the entity what they can do. I can tell you that if in a litigated case, there is a provision like that, and there is a termination clause and a value clause, that might help the entity itself, because then they're letting the physician go and money is exchanging hands. It doesn't solve all the problems for the physician necessarily, because then he or she is looking at a situation where there will be some expectation of employment, especially if that person was the primary earner for the family. The judge is not going to simply accept that they're unemployable at that point, right? So they will have to obtain some sort of employment, and what they earn would have to be commensurate with what is a standard earning for that type of employment in the community. Because if there isn't, that's a concern for the physician as well, in terms of a judge possibly setting any spousal support or any child support based on what they earned previously rather than what they're making now, because there's an allegation that it was intentional to diminish any spousal support or any child support. As you pointed out earlier, not all of your listeners are in Illinois, so it's important for them to know that not all states treat spousal support or child support the same way. There are states like Illinois where there's a guideline, and if the parties can't agree, a judge is most likely to default to that guideline unless there are extenuating circumstances and they're deviating either up or down on that guideline. But there might be states where there is no guideline, where a judge makes a decision based on certain factors in the statutes, which is where we were in Illinois 5 to 10 years ago. The guidelines are fairly recent in terms of spousal support.
Makes sense. So I guess let's talk about death. I mean, I know divorce is a big thing, but death is also important. And, you know, we often have an issue with a dentist or a doctor or other type of professional who passes away. I mean, they're people, right? They die from time to time.
Of course, we all are.
Right, exactly. Or they become very, totally disabled and they cannot operate their business affairs. We always have this issue where if you're not a licensed person, you can't own the practice. You can't inherit the shares or the units, etc. And it becomes problematic. Usually if there are well-written documents, this is addressed. So if somebody dies, then immediately they're redeemed. If there's other partners there, obviously. Disability, it's not always quite as clear, but very often that spouse wants to take on that role, ownership in the surgery center, which can be very lucrative, right? And or ownership in practice. Have you come across this at all? Is this anything that you've had to deal, or do you usually find that entities are drafting their documents pretty well to deal with these issues?
Well, first of all, again, it depends on how the entity has drafted the documents, right? But it also ties into state licensing. In Illinois, it's very similar for attorneys than it is for physicians. If my spouse is not an attorney, they can't just take over my law firm and start running that firm. So they would have to transition the clients, the patients, to other licensed professionals and close down the practice. So it's not just how the documents are drafted, but what the state law would allow. And for that, I would encourage your listeners to plan in advance and talk to their attorneys in terms of how the documents in the practice should be structured, and also take care of your estate planning needs and review them from time to time.
Really important. And of course, if you're not the only owner of a practice, that's really where those documents come in, where it says if somebody dies or becomes disabled, that they get bought out. And that's really what I'm talking about, by making sure, a lot of people just do verbal agreements and they never put things in writing, and then they hope for the best. And that's a really troubling situation. You're not protecting your spouse or your family when you're doing that, right? So
Absolutely.
it is an issue that we need to deal with from time to time, and it can be easily kind of prevented, right?
Yeah. Yeah, and I know that talking about death and planning for death is often a tricky subject. And whenever I have the conversation, I tell my clients it's the last gift you're giving your family. Rather than leaving them with a mess that they will have to clean up, you're
Right.
taking care of things now.
Absolutely. And let's talk about kind of asset protection as well. I don't know if this is a little off topic for you, but doctors are aware that they could be sued for malpractice, and a lot of them think asset protection is putting stuff in their spouse's name instead of their name and stuff like that. And is that really a good mechanism? Does it really work? Or can somebody go after, the house, the fact that you put it in the spouse's name doesn't really, or the kid's name, or a trust owned by the kids, or does that really save anything?
So it is a little bit outside of my area. I would suggest that they talk with someone like you in terms of what should be done, what can be done to protect them. From the divorce lawyer perspective, when I hear of someone putting all the assets in the spouse's name, I have alarm bells going off in my head for a very different reason than protecting from liability or a lawsuit. So again, my suggestion would be talk to your attorney, someone who can help you really look at the structure and how to protect yourself and your family without creating other issues.
Great advice.
So you mentioned the alarm bells. So what alarm bells are coming off in your head about leaving a lot of the assets with the spouse instead?
Just in case there is a divorce and it's not a collaborative divorce, what sort of a mess are we going to be dealing with in a divorce setting?
Right. So I only put it in his name or her name for asset protection. It's not really his or hers, right? It's both parties or something like that.
That the answer is no, right, to that one. If you put it in their name, granted, a judge in divorce court can retitle property,
Right.
but I would be concerned. I would not advise someone to use that as a method of protecting their assets in the event of a lawsuit.
It's super common, like crazy. A lot of times when I work on transaction or somebody's involved with litigation, one of the questions would be, what do you have? What you have to declare all your assets and what do you have? Oh, nothing. I don't have anything, right? Because it's all in my spouse. And I'm never, I'm always kind of surprised that sophisticated people do things like that, because it's not that hard to look through, right? So I guess, one of the things I wanted to ask about is, there's a lot of transactions going on in healthcare right now. So people selling their practices to hospitals or private equity. And, some of them are happily married, some of them maybe not so. And so when you've got a deal on the table and, are expecting to get quite a payday, at that point, is it too late to start thinking about, I don't want to call it, what happens if you and your spouse don't make it, but I guess that's exactly what it is. I often have clients say to me, I'm about to get a $20 million payday here. Everything's fine, but just in case, is there a way for me to put some of this aside just for me? And so I'm kind of curious what you think.
That would be a good time to look at post-nuptial agreement, because it's very similar to a prenup in that you want each person to be represented by an independent attorney. You want full financial disclosure. You want sufficient time to think about it. And with a postnuptial agreement, there has to be something of value that exchanges hands. With a prenup, the act of getting married, of going through with the marriage, is that something of value. But if you're creating a postnuptial agreement, there has to be something financial that exchanges hands. But you could, in a postnup, specify how assets and debts and income would be shared and what property rights there are or will continue post execution of that agreement. So that might be something to consider at that point in time.
That makes sense. So I guess, even if things are good, it's not too late to plan ahead, especially where you're getting a large sum of money, right? Makes sense. All right, so this has been a really fascinating topic. Are there any final thoughts that either one of you wants to share? Any final questions you want to ask?
Do you have an example, Anna, of say a client requesting multiple postnups and what situations arose leading to those?
I have not had one client requesting multiple postnups, but it's not impossible. There could be changes in the financial situation. So for example, let's say there is a sale of a practice, right? And they're not buying into another practice. So they execute a post-nup. And then maybe there's a development where children emancipate, or maybe the other spouse becomes disabled to some extent, physically, because you want to make sure you have capacity to enter into a contract. For purposes of this example. So maybe there's another layer that you're trying to address, and then you would have another post-nup that you're executing.
Oh, that's a great question, Lesley. I mean, I guess I didn't really think about it, but there's really no reason that different life events couldn't lead to different agreements among the parties, right? So it's very possible.
Exactly.
Perfect. All right, Anna, well, any final thoughts you want to share with us today?
Thank you for inviting me to join. This was a very interesting conversation and I enjoyed it.
Well, I'm glad to have you. And obviously, I think this is a really hot topic because so many, healthcare professionals out there, getting married and divorced, they're buying and selling businesses, they're making investments, but they're not really talking about this process, how they can make it easier for them and their loved ones, how they can make it easier for the practice. And I think it's something that if everybody talked about a little bit more, we might move towards a less litigious approach, which would obviously be less expensive, which would be great for everyone, right? But also maybe better protect those spouses perhaps who are lower earning, because people talked about it at the start. So thank you so much for joining us.
My pleasure.
And thank all of you for joining us on the Health Law Hotspot. We hope you'll join us again. You can find out more about us at ralaw.com, and we'll share Anna's information when we post this on social media. And we hope you'll reach out to her or to us with any questions that you may have. Thanks so much. We'll see you next time.
The Retzel Health Law Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Retzel Health Law Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Retzel Health Law Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.